John, what are the basics of estate planning?
The basic of estate planning are broken down into multiple areas. First thing is what I call healthcare proxies and wealthcare proxies. Those things are something that everybody, whether you're 20 or whatever your age is, everyone should have them. Power of attorney takes care of your wealth, wherein you go ahead and you assign an agent to take care of anything that you're unable to take care of if you become incapacitated. And incapacity could be nothing more than you have a broken leg and you really can't make it to that closing 2 weeks from now. Or it could be that you're on drugs after surgery laying in a hospital bed. So the fact is, the power of attorney allows your agent, and when you're married, it's usually your spouse is the first agent. And we always want to have at least one additional successor or substitute agent if the first agent can't act. And those people are able now to do anything at all that you would do if you weren't in a position wherein you were incapacitated. Now keep in mind, you don't have to be capacitated. All you want to do is you don't want to do it yourself. You want your agent to do it. And there are about 50 different things that we put in that document indicating the kinds of things the agent is able to do. Okay, it's a very extensive document. It's your typical things: bank transaction, cash checks, make deposits, write checks, pay bills, pay taxes, do an estate process if you need to. Somebody leaves you some property and you're unable to participate, your agent can go ahead and do it. But there are two very additional important things that we always put into the power of attorney. One is the ability for your agent to go ahead and put together a trust if in fact you ever need one. So for example, if one person has a stroke and they really don't have the ability to go ahead and put together this trust, they've lost that capacity in terms of that sort of transaction. So the person who's the agent can now go ahead and put together that trust for them, which can be a big help for the house and other things, and also for other healthcare issues such as Medicaid applications. So that can be extraordinarily important. The other thing that we put into our power of attorney, in addition to all of the other regular things that happen, is we designate within there the principal is the person who's saying, this is my healthcare process. The person who is going to take over things is the agent. That person also, you want to designate that agent to be the person who could be your guardian if you ever need a guardian. In New York State and in almost every state, there's a process for guardianship. If you just go into court without that document, you're going to have to convince the judge someone else is going to convince the judge who should be the guardian. If you have it in your power of attorney, you've already pre-selected an agent, so that this way the judge will know this is what Mike wanted to do if he was ever in that position. So that's first. A wealth care proxy takes care of all of your assets. You appoint an agent to do that sort of thing, to do those operations, which is extremely important, as you would imagine. The other thing are healthcare proxies. Healthcare proxy is the person you select as your agent to take care of your health. Okay? What happens if I suddenly have an incurable disease and I'm in a coma? I can't make the decision for what's going to happen to me. I can't say how much treatment or how little treatment I want, but I can designate an agent who can do that for me, and they will have already been told by me, and I've also put the information into the document itself, so they'll know exactly what needs to be done.
And when you say an agent, that could be a family member.
Generally speaking, married couple is usually the spouse, and then sometimes in my own case, I have 3 children. Okay, all of them get along great, they're wonderful. I didn't think anybody would do a better job than anybody else, so I just went by age order.
Right.
Except my son who's in Ohio, I took him out of the mix and made him number 3, because he's going to be far away. It'll be much easier for the other people, the other family members to do it.
Right.
Sometimes it could very well be a doctor that you would select to be your agent, another family member, a trusted business partner. You know, there are many, many different choices, and that's why it has to be a conversation that's a mile wide and a mile deep to get a sense of exactly what needs to be done in your particular situation. Okay?
Such important information.
Then the second basis is, what do I do with all my stuff? Well, the basic way to deal with your stuff is to put together a will. Okay? But a will is something that won't protect many of your assets. That's why it's important to have a trust, because a will must go into probate in order to pass the assets. And I've mentioned the different problems we have with going to probate because of the extreme cost and time consumption and so on and so forth. But it still is a good idea to have a will, because anybody who you were related to or had a business relationship with, that person can go ahead and file a petition saying you promised them that you were going to give them an amount of money.
Right.
Well, your will can be evidence as to why, in fact, there's no other person who should be an heir of yours other than the people who you've mentioned.
Okay.
Okay, so we always do a will as well. And then, of course, the trust, as I mentioned, is as many family situations as there could be. Whatever the combination is, they all can be taken care of within the trust.
Great.
In great degree. And one other thing I should mention about the basics of estate planning, estate planning isn't something you do once. It's something that you should look at every 2 to 3 years, or whenever there's a life-changing circumstance. More children are born, someone passes away, someone who is going to be an agent dies, there's a divorce, there's all
Someone who acquires more property.
yeah. And that's why you should be consulting your attorney who's doing your estate planning at least every 3 years, and most attorneys will reach out to their clients just to say hi and see if there's any reason for further conversation about changes to the documents.
Got it. John, as a real estate broker, what are some of the mistakes people make when selling inherited property?
First of all, inherited property, we assume that they're in the probate court to distribute the asset. The biggest mistake they made was by going there and not putting the house into a trust previously. Because then the people who are inheriting the house, the trustee, it would just automatically be able to sell the house.
Right.
Because it would be in the John Zenir Family Trust. John's dead, new trustee is Billy Zenir, and Billy Zenir just takes the property, sells it, shows the death certificate, and the trust, it's already in, the title is actually in the name of the trust, okay, and there it just passes automatically. So there's nothing that has to be done.
So like the Billy Joel song, it's a matter of trust.
That's right. Exactly. Good idea. We should have started the whole conversation with that song in the back.
One thing that I saw with my own situation with my father, it's so important to have this laid out because people don't realize the cost of care and Medicaid and Medicare. Like Medicare, you get some care, but people don't even realize that you got to get yourself on Medicaid to get the care you should have. And if someone's got money and assets, it could be a big problem.
Well, there's no question. You know, that's why there's one type of trust called a Medicaid Asset Protection Trust. That's an irrevocable trust. What we do there, as long as the asset, the house, is in the trust for 5 years, it passes outside of the estate. Okay, and Medicaid cannot go back and reach back to bill the client for any nursing home care they've been having. And that's a big number. It's like $16,000 a month here in New York State, I believe.
Yeah.
It's not cheap. It
Yeah.
makes all the difference in the world.
It would be great to avoid nursing homes altogether.
A lot of times people are concerned, gee, I don't know if I want to put this house into a trust and take it out of my and my spouse's name. With the first kind of trust we were talking about, the revocable trust, the parents become the first trustee. They always have control.
Right.
It's only if you're looking to avoid Medicaid, which is reach back on the property, where you're making an irrevocable trust, where the parents no longer have control because now the trustees can make any decisions.
Got it.
But what do? You make sure you have someone who is going to do the best for you and not going to be a concern. An irrevocable trust can be broken, but it's a technical rigmarole to go through it that for our purposes, there's no reason to have a conversation about it right now.
Right.
You know? But there are so many things that can be done. And unfortunately, the basic feeling that, gee, this is my house, it's in my name, I don't know that I want it to be in a trust.
Right.
Okay? But when you're the trustee, at that point, you can still take a mortgage out on the property, you can sell the property, you get all of the same deductions, military deductions, senior citizen deduction, anything at all that you would have had when it was in your name, you're still going to get.
Right.
So it's not a problem. You're not losing any rights whatsoever by putting the house into a trust.
From a real estate perspective, when someone inherits a house and there may not be assets to cover the bills and everything that goes forward, people will go right to the realtor and say, I got to sell the house, and they don't even know that they may not be able to.
You may not be able to sell the house.
So it's so important to check on these things as a realtor to make sure that the home is sellable and it doesn't become a big issue.
I had a case not too long ago. I think it was an 80-year-old man owned a co-op in Queens, small co-op, that had become popular during COVID because people were now using these small co-ops as offices, and residences at the same time. And what happened was that the only heir he had left was his sister, who was 75. Now, generally speaking, 75-year-old people don't have the greatest income at that stage of their life. So this poor woman, she had to pay the taxes, she had to pay the electric bill, she had to pay all the carrying charges during this 18 months that it took to get the approval to sell the co-op. And what she did is she wound up borrowing from her son.
Right.
Because she did not have the assets. That could be a real burden. Another reason why you want to pass the house as quickly as possible. And what could be better for a real estate broker than to know that the house is saleable, now can be sold next Tuesday?
Of course. That's what I want for all my clients, to be able to sell their homes when they need to and have no encumbrances that they have to deal with. I mean, I think we learned a lot today about what we should do to protect ourselves, and very important information. And John, thank you so much.
It's my pleasure. It's always great to have a conversation about staying away from probate, because that's my purpose at this phase of my working career. I just want to make sure everyone starts talking about why you need to stay away from probate. Because the more conversation that's out there, the more information, the more knowledge, and people will begin to do the smart thing.
That's the point of today. Again, thank you.
Thank you. It was fun.